Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, just that we ask that the court follow the plea agreement we have with the state.
All right, the court will find you guilty. The court will sentence you to 180 days in the Bexar County Jail under 1244. There's an $800 fine, time and money to run concurrent, and there's to be no residing in households with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You need to make sure.
They walked into court with entitlement and walked out completely wrecked by the judge.
Happy belated birthday.
Oh, no, it hasn't started yet.
When is it?
It's in November.
But that's a birthday.
Yeah, but I celebrate the entire month.
Okay.
So,
I try to. So.
oh, we all should. All right, the court is calling 2025 CR 010492, State versus Billy Joe Reynolds. Can I have parties announced?
Megan Galloway for the state.
Deborah Stantonberg for the defendant.
And are you Mr. Reynolds?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
And probation, this is an application. Court will find that the state is in compliance with discovery. Mr. Reynolds, did you review the application for community supervision with your attorney? Did you understand it and sign it?
I did, Judge.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
Yes, we waive it.
State, are you proceeding on the indictment as presented?
We're waiving the punishment.
I'm sorry, could you repeat that?
Waiving the punishment enhancements, Your Honor.
Any objection?
No objection.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Reynolds, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
I am.
Did you understand if you're not a U.S. citizen, by entering into this plea, you will be deported, denied naturalization, and re-entry?
Yes, ma'am.
This hearing moves fast, but every answer here carries long-term consequences. Guilt is already established. What's left is control, risk, and whether the court believes this defendant can follow rules. From this point on, the judge is deciding how much trust is still left.
All right. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's a $1,000 fine. State recommends community supervision. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There'll be 200 hours of community service restitution, TAP evaluation, no contact with Oscar Ramirez or Jade Ward. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
The offer states one in attachments.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
All right, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, we hope so.
Anything you wish to say on behalf of your client?
We certainly hope that you follow our plea agreement. And my client was arrested this morning when he appeared in court. He was supposed to come Thursday. Of course, I contacted Norma on Friday.
When the judge asks about employment and drug use, this is not casual conversation. A long employment gap and admitted relapse tell the court supervision must be strict. Honesty helps, but it also justifies tighter probation conditions.
I didn't ask, could I bring him Tuesday? He came today because he didn't know court was Thursday.
Okay.
But he came when I told him.
Okay. So when's the last time you've been employed?
Gainfully employed, probably 2011.
All right. So what do you do? How do you support yourself?
I get a small pension from the military and also disability. I'm service-connected disabled.
Okay. And so when did the drug use start?
It's been a long time ago. It was sporadic, back and forth.
Mhm.
Went through treatment. It worked. Become bored after a few years and started using it again and then dropped it again.
Mhm.
Well, I quit drinking in 2000 and I hadn't picked up a drop, but it was sporadic with the drug use.
Okay.
Defense frames contact as helping a friend, but the judge shuts that down immediately. In a drug case, child safety overrides personal relationships. Until sobriety is proven, the court allows zero risk.
And so do you have a home to live in?
Yes, ma'am.
And the people that they say no contact, were these people that you were hanging around with?
No, the one person, no, I just barely even know him. But
Oscar, he doesn't know.
yeah, Oscar. But Jade was a personal friend, very close to.
And he hopes that you won't impose no contact because he actually helps her and her son. Like he was supposed to pick up her son from school today.
Yeah.
They're just really, really good friends. I understand that it's not in the plea agreement, it's recommended by the state. And we hope that the court will let him have contact, but order.
I'm not trying to make more work for you or her.
No. Let me just tell you the reason why I'm not going to allow contact.
Okay.
Suspended sentence sounds like mercy, but probation is pressure. Every rule listed becomes a trigger point. One mistake in jail becomes automatic. This is not freedom, it's conditional survival.
Because this is a drug case.
Yeah.
I mean, you really shouldn't be picking up children from school. This is a drug case. And, until you prove to the court that you can be clean and sober and stay clean and sober, can't have that.
It makes sense.
Okay. All right. The court is finding you guilty. The court is going to sentence you to 2 years in the state jail facility, suspended and probated for 2 years. There's a $1,000 fine to be probated. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment or
disability.
okay, stop interrupting. Sorry. All right. So proof of employment.
Yes, ma'am.
Because this was a plea bargain, the right to appeal is gone. The felony conviction now affects weapons rights, employment, and future exposure to the system. This moment closes doors permanently, not temporarily.
Within 45 days, or proof of your pension or retirement within 45 days. If you're not able to provide that proof, then you're going to have to get employment. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. There's to be no contact with Oscar Ramirez
Mhm.
or Jade Ward. There's to be a TAP evaluation out of custody, 200 hours of community service restitution. And for every sober support meeting you complete, an hour will be deducted from your community service hours.
As the next case begins, tension shifts from sentencing to representation. The judge makes it clear, lawyers are not friends, they are professionals. Disagreement does not equal ineffective counsel, and courtroom decorum is not optional.
I'll explain to you.
Okay.
Field visits 1 time per month for 6 months. Probation, is there anything else? Is there anything else you need from the court?
No, ma'am, I think you covered everything.
All right, and Deputy Laura, you can recall the warrant. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Oh, and probation, if you can do a referral to Veterans Treatment Court. All right, good luck to you.
Thank you, ma'am.
Oh, you're welcome.
Thank you.
You're welcome. Have a good one.
May I be excused?
Yes.
You know I'm only chuckling because I've been here so long.
Oh, hey,
Thank you.
you're welcome.
Go to the box, I will tell you. Well, actually, go to over here.
Yes, just go.
The first row.
This entire sequence shows how quickly courtroom power shifts. One defendant walks out on probation under strict control, another faces conflict before trial even begins. Do you think the court handled both situations fairly? Share your thoughts in the comments. Hit like if you value real courtroom breakdowns, and subscribe for more cases where every ruling changes someone's future.
All right, so in this case, the competency evaluation, has that been completed?
It has, Judge, came back as competent.
All right, and are you the first attorney on this case, or the second, or?
I'm the second attorney, Judge.
Mhm.
Previously, I believe Mr. Leal was on his case, but he didn't show up a couple of times.
Okay.
I think the MAC put me in his stead at that point, Judge.
Mhm.
But there's been some issues with communication, in my opinion. I don't file motions to withdraw often. In fact,
I know,
believe
I've
that
never seen one.
This is the first one in your court, Judge, so it's not a reason for delay. But I feel like the attorney-client relationship in this circumstance of Mr. Folsom has deteriorated. He's not heeding any sort of defensive advice from me. And I don't know the reason why, but
This is where probation turns serious. The judge stacks condition after condition: job proof, no minors, no specific contacts, treatment, community service. This isn't flexibility, it's control with consequences.
I just feel like representation with Mr. Folsom moving forward would not afford him the best defense, being that he's in like the cut of my jib. Whatever
doesn't
reason it
like
may be,
what?
the cut of my jib, like the way that I am, just I don't know what's the
So
reason.
here's the thing. In the words of John Wayne and Cowboys, we're not here to make friends. Everybody's here to do a job. Nobody's inviting you to their house for dinner. Defense attorneys, and I've been a defense attorney, they can't force the state to give a dismissal if you think you should have a dismissal. They're not holding one in their back pocket. Your attorney will look over the facts of the case and they will say, hey, this is what the state says they have, right?
Mhm.
And normally what I can tell you is in police reports, when police reports are filed, Usually people expect people to say what's in the police report. Like, for example, this is a DWI third. Nobody's expecting the police officer to come in and say, you know what? Actually, I didn't see any signs of intoxication. That's just going to be up for your counsel to cross-examine them.
Mm-hmm.
So I don't understand this about bedside manner or whatever.
Well, Your Honor,
Yeah.
you know, I was in the driveway at this house.
No,
and-
here's the thing. No, here's the thing. We're not here to talk. We're not here to talk about the facts of the case.
No,
But this,
facts.
this is what I will tell you, what I've discovered too,
Mm-hmm.
which I don't know who came up with this idea. People think if they're alleged to have committed a crime, if they make it to their house,
No, that's not
everything's
that.
okay. But so here's the thing.
Mm-hmm.
Your attorney doesn't have to be your best friend. Your attorney is not trying to be your
Fine.
best friend.
This moment quietly locks everything in. A plea bargain means no appeal, and a felony conviction means permanent weapon restrictions. These consequences don't end with probation, they follow for life.
Best friend.
All right. So I'm sure he's told you what he
Okay.
thinks are the good points about your case and the bad points about your case.
Mm-hmm. But I was there. He wasn't.
Well, then that
And,
means, do you want to testify?
Like I said, yes, ma'am.
Okay, then he'll give you,
It's just, it's been a
It's,
combative nature throughout the whole course representation, Judge. We were in court earlier and he was being loud and verbally abusive. I just, it's, I think difficult to proceed moving forward. Every specific defensive advice I've given, it's just been heated with the combativeness. So I don't know, maybe he might have better luck with a different attorney. I think he's requesting, I had my colleague speak to him as well, and he communicated to her that he's requesting a different attorney, which is why I filed this motion.
so are you gonna hire an attorney?
Probably not. You know why? Because I've been locked up for going on 16, 17 months.
Mhm.
And everything's been taken away from me.
Mhm.
And I don't think I did nothing wrong, tell you the truth. And you know, it's here it is again, the same old thing. And it's always up to somebody else to make a decision.
Mhm.
And you know, I'm sick of it.
Okay, all right, you can be brought, you're scheduled for a bench trial.
Mm-hmm. A bench
So-
trial for what? And I would
For
like
these
to know
charges.
what charges?
The charges that,
The courtroom energy shifts instantly. Now it's not about sentencing, it's about competence, communication, and whether this case can even move forward without chaos.
that you're here for, you're here because you've been accused and indicted for driving while intoxicated third or more.
Mm-hmm. Okay,
So-
where's my vehicle? Is what I'd like to know. It was took out of my driveway for evidence. And I'd like to know.
Your Honor, I
So
didn't know that it was towed and it's at the Groundon lot.
I told him right when I met him that the car was taken out of my driveway from the police officers and the record. And nobody has told me anything about it. I've asked about the gash in my arm right here from the police officer and the nurse over there on SAPD. Nobody has said nothing about that, but everybody continues to do whatever they want. But you know, I'm trying to find out where's the good faith based people at.
I understand what you're saying.
I mean, I think a lot of it's been brung in bad faith.
Mhm.
Let's go ahead and put it to where I was evaluated. There's nothing wrong with me.
I'll tell you,
Okay.
sometimes people will be evaluated because legally,
Mm-hmm.
Judge draws a hard line here. Attorneys aren't friends, and they can't rewrite police reports or force dismissals. Court is about reality, not comfort.
if you feel that someone should be evaluated and they're not evaluated, and then you go through a jury trial or whatever you go through, and it doesn't turn out the way someone wants it to be,
Mm-hmm.
then that can be appealed on grounds that, hey, this person should have been evaluated. What were you all doing? So this is what we're going to do. I'm going to have you recalled for tomorrow. And I'll take up that. Are you going to be here tomorrow, counsel?
Yes, Your Honor.
All right, I'm going to take up this motion tomorrow. Deputy, have him dressed tomorrow, please.
And that's another thing right there, Your Honor. The family member took my dress out clothes to the office right here.
Mhm.
It's never been showed up over there at the police
Oh,
department.
sometimes
Sometimes.
as it happens.
Yeah, it happens, you know.
Mhm.
It does, like everything else. And that's how come I'm sorry that I'm not dressed properly.
No, that's okay.
You can make the
They're,
proper
they're,
But it's been 6-7 months.
yeah, we're going to make sure that you're dressed properly, okay?
Yeah, that'd be fine.
Okay. All right, thank you so much.
Thank you very much. You have a nice day.
All right, you too, Mr. Folsom.
Thank you, Your Honor.
Welcome.
Frustration takes over, but the court doesn't follow emotion, it follows process. Complaints about fairness don't erase charges, and belief doesn't replace evidence.
Did you sign in? Hey, you know what? You got to follow rules. You know what? If we see, this is what, Robert, this is what I tell people. It's not the zombie apocalypse right now. There are rules. You're skipping over people.
This would take 10 seconds.
Will it though?
Not anymore.
All right, who's next?
I'll be willing to wait 10 seconds.
And who's after Orlando?
Nobody.
Do you want him to? All right. See, he's not even, look, hasn't even filled it out. We're waiting for you. Adam loves to tell everybody, I've been to her house.
Is this on YouTube? I have been to your house. What was the story
I still-
yesterday about
I
the
still-
flowers? Well, I couldn't hear it from way back.
Oh, no. So anyway, my mom has always told me, and she told my brothers too, if you're working full time, right? Of course, the only exception if you have children to take care of, because they should come first with spending. But she said, if you're working, you should be able to spend one thing for yourself, right? And she always tells me that other than being at your home, the most time you spend your time is at work. And she's like, you should try to make it as beautiful as possible. So flowers are like $20 and I'll call. I'm like, Mom, that's $20. She said, if you can't spend $20 on yourself, then maybe you shouldn't be working. Now, mind you, that would mean that I'd go live back home with
Your
my
mom
mom.
is false.
Yeah.
This clip shows how fast a courtroom can lose patience. The judge isn't angry, she's enforcing order. Skipping rules, skipping steps, even small delays get shut down immediately in a live docket.
You know, when I had my first job and my mom, she knew all things union. So she would say, this is when you get your break. This is when you get, this is when you're supposed to be off. So my first job, I was there at 7 a.m., didn't leave till midnight.
And what was the start time? Was it at 7?
Hmm?
When were you getting there at 7? So
7.
you didn't get there at 6:45.
No.
Okay.
Oh, I was there at 7. And you know how much I got paid for that full day of work after FICA said, we need something from you? I think I got paid maybe $25. And my mom was like, no, this is not good.
Yep. I think when I started, it was like $4.25 an hour, something like that,
Mhm.
$3.75, something way back when.
What sounds like casual talk actually carries a message. The judge's story about woke, pay, and self-respect isn't random. It's perspective. Court isn't just about law. It's about accountability and reality.
Yeah, I was. They would always say, what does Stephanie say? I'm like, hey, I'm barely 17.
Sally Field.
Because that store also, they would make you come in, and when it was inventory, they would have workers come in, and do you know they wouldn't pay them for inventory? And I said, this is odd.
I like service merchandise because you could do labor that. If you remember that.
Yeah.
I'd be excused, Judge.
Oh, yes, have a good one. And he wasn't on the, was he on the docket? Page 8, okay. All right, who do you have?
I think you're on Rogelio Ibarra.
All right, what page is he on? All right, thank you. Rogelio Ibarra.
This is where things quietly get serious. The judge makes it clear discovery delays have limits. Miss the deadline, and the plea deal option disappears.
All right. Discovery, where are we?
I have received the discovery that we were requesting. I need to review it. We just received an offer today, though, Judge, and we do need some time to consider that as I review that additional discovery.
All right, I need an acknowledgement of discovery done. And how old are you?
18.
All right, Ms. Ferguson, I need a 30-day reset for plea deadline. All right, so you're going to come back on November 20th. At that time, you need to let me know whether or not you reached an agreement with the state. If you have not, your next court date is going to be a jury trial date, and the court will not accept any plea bargain agreements after that date without good cause. Otherwise, you have to plead open to the court. Do you understand?
Yes, ma'am.
All right, thank you for dressing appropriately for court. Just have a seat. Once you sign the reset form, you're excused. Who's next?
Page 5, second.
Here's a moment defendants often underestimate. Once a plea deadline passes, the court won't negotiate anymore. From that point on, it's trial or open sentencing, no safety net.
Julius Martinez.
Good morning, John.
Good morning. How are you doing?
I'm good. How are you?
Oh,
Just
I
getting
think-
older every day.
You know what? But what is the other alternative?
Ah,
So I'm fine with the getting older part.
oh, I'm gonna be 73 in December.
Yeah, but you know what? The key is you don't look it. So where are we on discovery?
Oh, Your Honor, I don't, just today I compared with the state, and I wasn't getting the videos. I couldn't get the videos downloaded. I made sure that they were there. So I believe, I don't know if it's my end or not. So I'd like a chance. And then today they just gave me an offer. So I like to look at the videos. They're very important in this case.
Mhm.
And so, in order for me to recommend to my client or make a recommendation to my client.
All right, Ms. Ferguson, if I can get a 30-day reset for a plea deadline date. All right, we'll have you back on November 20th,
Yes, ma'am.
and that will be your plea deadline date. Once you sign that, you're excused. Thank you for dressing appropriately for court. Have a seat. Your attorney will bring the form to you.
Thank you, Judge.
Thank you. You're welcome. All right, who else?
Oh, I have one more, Your Honor, but staying on this side. Okay.
This final clip shows the courtroom machine at work. Case after case, no pauses, no drama, just control and efficiency. The system keeps moving, whether people are ready or not.
Are you ready for one?
Yes.
Page 3 at the bottom, Enrique Lopez.
Enrique Lopez.
Good morning, Your Honor.
Good morning. Where's Mr. Lopez?
He's right there, Your Honor.
He needs to come down.
We had coffee earlier.
I was talking to Spears.
All right, what is happening with this case?
Your Honor, I'm just asking for a brief reset. We have all the discovery. I just haven't had time to look through it all yet. So I just need some time to review the discovery.
All right, Ms. Ferguson, recall this in 3 weeks for disposition, please.
Did you on November 13th?
All right, we'll see you back on November 13th.
Would we be able to do that the following week, Your Honor? I'm scheduled to be out of town that day.
See something. All right, we can recall it on November 6th.
November 6th?
Mhm.
Okay.
All right. Nora, put it down for November 6th. All right, we'll see you back on November 6th.
Thank you.
Thank you.
Thank you, Your Honor.
You're welcome. Who's next?
I have John C. Lopez, page two down.
James Ross.
No, which Lopez? John Castro Lopez has already been done.
He's pretty funny. Lopez.
Is it John Castro Lopez?
Yes.
Page two down.
All right. Mr. Lopez?
John.
This is a routine request, but the court keeps it tight. Discovery exists, but preparation matters. The judge allows a reset, not because of excuses, but because the process still has to be respected.
Hello. So where are we on this case?
Judge, I filed a motion for continuance. I have, luckily, one of my cases that was set for trial in Comal County was reset this morning, even though I announced it. Then I have another case in the 437 set for trial this morning. And I'm asking that on top of it, I have an expert that needs to come to the district attorney's office to review the files, and he hasn't been able to. He was just recently appointed a couple of weeks ago, I think, and I need to have him review the files with the district attorney, and I need the continuance.
All right. So the court will see y'all here tomorrow for jury trial because this has been going on for a while with plea deadline dates. Plea deadline dates have been extended. And then we had a final plea deadline date. Then people wanted to jury trial. So Deputy Laura, he's to be brought tomorrow and dressed for trial.
Yes, Judge.
All right. Thank you.
We'll have a seat there. Do you want the motion for continuance, Judge?
No. All right. Who's next?
I have James Ross. Page 9, it looks like one down.
James Ross. Is this a motion to revoke?
Do the motion.
Yes.
James Ross, thank you.
All righty.
Mr. Ross, coming, Judge.
Here's where patience runs out. Multiple plea deadlines have already passed, and the court refuses to delay again. This case moves to jury trial. No more extensions, no more negotiations.
All right, we're set for contested hearing. State, are you ready?
Yes, sir.
Okay.
We're not ready, Judge, if that's appropriate to say at this time.
I mean, yes, but I mean, it's set for a contested, so it's going.
Well, I wanted to bring something to the court's attention, if
Okay.
I may. Mr. Ross and I, as the court was probably privy to, are not on the same page in very substantial ways. Such that I don't think that it would be productive or civil for me to continue representing him.
I mean, I understand what you're saying, counsel, but we were here in August and it was set for a contested hearing for October 9th.
Mm-hmm.
And then it was reset for today for a contested hearing. So the state has their witnesses. We're going to proceed.
I guess I'll say this, if I may. We're not getting along. I think it's very much affecting my wanting to and desire to represent him because I don't want to be cowered over and yelled at.
So here's the thing, you can't be yelling at people. That's it. So your attorney is here to represent you. You have a motion to revoke. You're on probation for possession of a controlled substance. penalty group 1, 4 to 200 grams. Your underlying is 8 years. So that means if the court were to find the allegations within the motion true, then you're looking at 8 years. Now, if you want to shout at your attorney, I don't know why you would do that. I don't know why you would raise your voice to your attorney.
The defense signals conflict, but timing matters. The court reminds everyone witnesses are present, the hearing is set, and the system won't stop because of tension between lawyer and client.
So we're going to proceed. Court is calling 2024 CR 008733, State versus James Ross Jr. Can I have parties announced for the record?
Needham McCray on behalf of Mr. Ross is to my right.
And are you James Ross Jr.? Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same James Ross Jr. who was placed on community supervision in 2024 CR 008733 for the offense of possession of a controlled substance, penalty group 1B, 4 grams to 200 grams on February 13th, 2025 for a term of 9 years? Is that you?
Yes, Your Honor.
State?
Condition number 2, on or about the first day of May 2025 in Bear County, Texas, the defendant, James Ross Jr., did then and there illegally use amphetamines and violence.
How do you plead to that? True or not true?
True, Your Honor.
Violation of condition number 2, on or about the first day of May 2025 in Bear County, Texas, the defendant, James Ross Jr., did then and there illegal use cocaine and violation of condition number 2.
How do you plead to that? True or not true?
True, Your Honor.
And then violation of condition number 4 in Bear County, Texas, the defendant James Ross Jr. did then and there fail to report to the supervision officer as directed for the months of May and June 2025 in violation of condition number 4.
How do you plead to that?
Not true, Your Honor. To one of them.
All right,
I
not
did not.
true to which one?
I did not.
Waive violation of condition number 1, 4, and 14, which is
Any objections to the waivers?
None.
Did you understand by pleading true to violations 2 and 2, the court could find it true, grant the motion,
Well, you know what?
and sentence you up to 8 years in the prison and up to $2,000 fine? Knowing that, do you still wish to plead true to violations?
This is the reality check. A motion to revoke isn't theoretical, it carries real prison time. The judge spells it out clearly. Probation violations can turn into an 8-year sentence.
2 and 2?
That the court's only option. And
No,
that,
I'm telling you what you're looking at. What you're looking at for any violation, it could be for littering. Any violation that is presented by pleading true, the court could sentence you to 8 years in the prison. Will I sentence you to 8 years in the prison? I don't know. I haven't heard anything with regards to that. But that is what you're looking at. And what I can tell you, whatever agreement you worked out with the state, if you have worked out an agreement, the court doesn't have to follow that agreement because this is a contract with the court. It's not a contract with your attorney. It's not a contract with the state. So by pleading true to 2 and 2, you are looking at a potentially 8 years in the prison and a $2,000 fine. Knowing that, do you still wish to plead true to violations of 2 and 2? That's either yes or no.
yes.
Court will find 2 and 2 true. Is there a proposed agreement?
Not to grant the state's motion, and for those 2 defendants, community supervision and sentence him to the 8 years in the prison based on the plea of truth here today, and then based on the underlying facts in the case that he's placed on probation. The state made punishment enhancements for that and recommended community supervision was done by a prior APA. And based on that amount that was he's in possession of at the time of the offense and continued use and possession of controlled substance.
All right, defense, what are you requesting?
Well, asking for drug treatment, Your Honor. I mean, he's on probation. He tested positive for some substances. It was obviously consistent with use. We all make mistakes. We all have relapses. He was on probation for a drug offense. And he made note to me. He said, the judge told me when I pled that if I ever have problems, to contact the probation department to let them know to work with them. And that reflects well on me if I ever came back.
Did he do that? Probation?
There would have to have a moment.
At this point, emotion no longer matters. The court regains control, explains the allegations, and moves forward. Whether the defendant is ready or not, the hearing proceeds.
All right, can you raise your right hand?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Deborah Higgins.
All right, counsel, you may proceed.
Thank you. And Ms. Higgins, you go by DJ, is that correct?
Correct.
Okay. What's your relationship with Cullen? How long have you known him?
I'm a family friend of approximately 14 years.
Do you remember how you first met the family?
I worked with Cullen's mom.
Okay. Was that in the Department of Defense
Yes.
area?
Yes.
Are you still working there?
No, sir. I retired July 25th this year.
And in the course of working with his mother, did you get to know Cullen a little bit?
Yes, I would go to their house for holidays and dinners and cookouts and whatnot.
What did you observe about Cullen during your period of knowing him?
He's a good kid. You know, he was raised well. I watched how him and his sister were raised. They were raised well. They did well.
Did you have occasion to see him with other young people?
I met one or two of his friends when we were all at the house. They're good kids.
And did you ever hear about anything that he might have done other than this incident that raised concerns for you?
No.
And you also work in pet safety or something?
Animal rescue.
Animal rescue.
Yes.
So you observed what happened today and you
Yes.
were familiar with it.
Yes.
So you do not condone bad behavior?
Absolutely not.
Okay.
Right is right and wrong is wrong.
You're hardcore on that.
Very.
Okay. And you know that what Cullen did was wrong.
Yes.
In spite of that, do you think that he could succeed on community supervision if the judge would give him that?
With structure, accountability, and discipline, and having to stay focused on that thing, yes, I do. I think he would do very well with that.
And do you think that would be a better outcome than sending him to prison?
I do.
This is a rare but serious moment. The court makes it clear, refusing to dress properly has consequences. Trial will proceed in an orange jumpsuit, and optics matter more than people realize.
Why is that?
There's prison structure and there's, I don't know the right legal term, but probation structure. And I think him being employed, being forced to do the right thing every single day in a more open environment would be more beneficial to him to grow as a young man.
Pass the witness.
Any questions?
No.
All right, thank you.
Thank you.
Call your next witness.
Yes. I would call Melissa Daly.
Hello. All right, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
I'm Melissa Daly.
All right, just keep your voice up so the court reporter can hear. Defense, you may proceed.
Thank you, Your Honor. Ms. Daly, you're acquainted with Cullen O'Neill, correct? How did you know Cullen O'Neill?
I've known Colin since he met my son practically in kindergarten. And all the groups of boys always played in the neighborhood. So I watched basically Colin grow up since kindergarten.
Okay.
And he's always showed the utmost respect and yes, ma'am. And when I had groceries, he'd be the first to come help me take them out of the car. I have him spend the night several times. And I treat him like a son of mine. So
Okay.
I have, this is totally out of character.
Mhm.
But
What is your son's name?
Daniel.
Daniel, and he is a friend and grew up with Colin, correct?
Yes, sir.
Is Daniel here?
Yeah.
Daniel, okay. Now, would you, if you had had any issues with Cullen as far as his influence, would you have allowed Daniel to spend time with Cullen?
I hadn't had any issues with Colin.
Right,
So,
but if you had.
Oh, of course I would.
Here, the attorney steps in and owns the mistake. But courtroom responsibility still lands on the defendant. Explanations don't pause proceedings. Preparation is expected.
But I have not seen, Colin's has always presented great character and integrity. And I thought when he was raised with his father hunting and having all the things that every boy would dream to have with a dad dude. And since his dad passed, it was very heartbreaking. But he had a group of friends that supported him. So he wasn't like a loner child. He had lots of friends. And that helped him get through that horrible situation during his prime time in childhood.
And do you think that that he would be a good candidate for probation, community supervision?
Yes, I do.
You think he could succeed on that?
I absolutely do think he succeeds. He's has high integrity, and this is just outside his character. This incident.
Thanks. Absolutely.
Any questions?
No, okay.
All right, thank you so much. Call your next witness.
I'm gonna call Cullen, Your Honor. Cullen O'Neill.
Can you raise your right hand?
Sir.
Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you
Yes, ma'am.
God? All right, you can lower your hand, state your name for the record.
Cullen O'Neill.
All right, defense, you may proceed.
Thank you. Cullen, you know why we're here?
Yes, I do. I made an egregious mistake one night. I had no sympathy for the situation I was in due to being under the influence of drugs and alcohol. And I made an honest young man mistake with my emotions and what I was trying to do. I made a horrible mistake. It's been haunting me. And I mean, I've had to deal with it for a year and a half that I've realized it and sat with it. And people have made fun of me. I've gone through it, but it's something that I know that it's not over because I made a mistake and I'm willing to take that on the chin. You know what I mean? You talk about football and LSU. I'm leaving it all on the field. You know what I mean? With what I'm trying to do to prove that I need a plea, but I made a mistake.
Okay. Now, the evening this happened, you had been using drugs, correct?
Yes, sir.
And you'd been drinking.
Yes, sir.
So you have an issue with drinking and with drugs.
Yes.
And you're willing to deal with that.
100%.
Okay.
To get better.
To get better. Do you have
This stretch shows the quiet reality of court. Long pauses, waiting for names, waiting for paperwork. The system doesn't rush. It moves when everything is in place.
attraction to younger women?
No, ma'am. I mean, no, sir. I've never once ever in my life. I think it was just the influence I was in, the situation of not sleeping, being tired from work, just and my emotions, my feelings as a young man just overcame me. And I know that's horrible and I made a mistake for that.
Okay. Now, you did complete your GED, correct?
Yes, sir, I did.
Okay. And do you have plans and things that you want to achieve in your life?
Yes. So I was a month away from finishing college when this all happened. And I had been held back for a year and a half to even finish college. But what I was doing in college was being a gunsmith. I get with my situation now, I might need to find a different line of work. And what I've been doing as an iron worker and doing stuff outside and building buildings like Chick-fil-A's, Walmart's, and Chase Banks and stuff around the community the best I can.
Now, you were employed with an iron, what kind of a company was it?
It was an iron company. It was Hill Country Steel. We do all the main steel around all of San Antonio, Austin, and Dallas. We do every Walmart, every Chick-fil-A, every Chase Bank, every car wash. We provide the steel.
Did you start working with them when you were in high school?
Yes, right out of high school. One of the letters I gave was from the employer that I've known since right out of high school. And he helped me a lot. And he knew about my situation through house arrest and getting my job back.
Now, you're not currently working for him, right?
No, I stopped working for him because I wanted to deal with this and didn't want to interrupt their company for my mistakes.
Okay. And are you hoping to be able to get work again?
Yes, I actually have a job interview on Thursday for another steel
A missing PSI is not a small issue. The judge immediately asks for documentation because sentencing decisions rely on reports, not assumptions.
company that was smaller that we used to provide steel with. So that's something I'm really looking forward to start doing and working.
Tell the judge why you think you could succeed on probation.
I did track, football, and baseball all throughout high school. And I work harder than most grown men that I know. And I know I messed up. And I don't want to do prison because that's just not something I know I will succeed in, unfortunately. But I know that doing the plea and being on a schedule, checking in and doing things like that will really help me a lot. Get my life back on track. I'm young. I made a horrible, horrible mistake for my age. And I know that I want to be able to recover from it and not be stuck.
Now, when this happened, understanding the situation, you do admit that you were told that the girl was 15.
Yes,
correct?
Yes,
and you also admit that when you were going to see her, it was because you were intending to have sex with her, right?
Yes, I admit to that. You know what I mean? I admit to the court to take my honesty because I made a mistake.
Yeah. But that's not something you have ever done.
Never thought about it, never once been around it. And I have a little sister. How could I do that to her?
Okay.
You know, like that's something that I really think about a lot and being a better image for her, especially with the situation I'm in. I want to get out of this and be better for her. And she was one of the main people
This final clip shows time pressure behind the scenes. Jail logistics don't wait. If attorneys aren't ready, defendants can be pulled out of court without warning.
What's going on? Oh, my sister-in-law came here and her wife, she lived with her boyfriend, but her boyfriend came with two other guys in an SUV. The boy came to my door and drugged her by the hair. And I said, get out of here, I'm gonna call the cops. The two guys were pointing the guns at the kids with a laser on it.
Was the information relayed to you by the people on scene? Was it being relayed to other units and they were acting as a search team?
Yes.
And did you obtain custody of the defendant at any time?
Yeah, of course.
And do you see him in the courtroom today?
I'm sorry.
Do you see him in the courtroom today?
Yes.
Can you please point him out with an article quoting?
Gentleman in the orange.
This case opens with instant danger. Allegations of armed men, laser sights, and panic change everything. The court is now dealing with fear, weapons, and rapid police response, not a simple dispute.
And when you came up there, did you obtain any of his personal belongings?
Yes.
What did you find in it?
Large amount of money, 2 cash out debit cards, 1 food stamp card, belonged to the girlfriend, I believe, and 1,100 in cash.
And do you remember whose name was on the cards in the fanny pack?
Yes, the cash out debit cards were under Alonzo Taylor, and the defense card was under Jackson. I don't remember last.
And were there any other substances in the bag?
Yes, there was a small amount of marijuana in the bag.
And how do you know it was marijuana?
Due to the odor, based on my training and experience, I believe the green substance, leafy substance that I saw in the clear bag inside the bag was marijuana.
Defense, you may proceed.
Thank you, Judge. Good afternoon, Officer Galvan. Just have a few questions for you. My name is Jonathan Alvarado. So you were basically the first officer on scene, is that correct?
Yes, sir.
Okay.
And I'm sorry, are you a witness for this case?
Facts start replacing chaos. The officer walks through custody, personal belongings, cash, cards, and suspected marijuana. But notice, observation is not the same as proof.
For Taylor?
Yes.
All right, so the rule has been invoked. All right, you may continue.
when you arrived on scene, you said you were able to notice a large dent, and I think you said you could even see it from where we're actually paused at in State's Exhibit 1. Is that correct?
Yes.
Okay. Did you notice any other signs of physical force regarding the door?
No,
Just the dent?
the dent.
Okay. Like no splintering, correct?
No,
No doors off the hinges, correct?
no,
No broken locks, correct?
no.
And I don't believe it was you, but somebody took some photos of the door, right?
Yes.
Okay. And in those photos, you don't see, you call it a large dent, but you don't see necessarily any footprint or something like that would indicate that it was kicked, for example.
This is classic cross-examination. No footprints, no broken locks, no field test. The defense isn't arguing emotion, it's questioning certainty.
Correct.
You didn't notice any footprints, that's my point.
No, I did not see that.
And to be clear, the individual you spoke to, whose name is Ashley Hurd, she said that the suspect had actually kicked the door, right?
Yes.
And have you seen doors before that have been kicked in?
Yes.
Okay, and you would agree with me that oftentimes they have footprints on them, right?
Yes.
Especially if it had happened recently. And so you don't really know what that dent was what it was caused by. Is that fair?
Yes.
You mentioned that eventually you took custody of the suspect, my client, at headquarters, right?
Yes.
Okay, and you said you found some stuff in his bag, right?
Yes.
Including what you believe to be.
When the rule is invoked, the courtroom tightens up. Witnesses are cut off from each other, and testimony becomes isolated. From here on, every word stands alone.
Marijuana.
Yes.
You didn't do like a field test of the marijuana, right?
No.
And as far as you know, that marijuana was never sent to a lab for confirmation to be illegal marijuana.
Not to my knowledge.
Pass witness, Judge.
All right, any further questions? Witness excused or subject for recall?
Excuse by the state, Your Honor.
Excused by defense.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone while this hearing is pending. All right, if you'll just leave the exhibit with the court reporter and you are excused. State, call your next witness.
Heard.
Stakes rise again. This isn't just about property or drugs. Children were inside the home. The court now balances credibility, emotion, and strict rules of evidence.